rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement, and a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. Can I add anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis. This is the state's motion in limine.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights, and they're certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because the defendant's phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point, and to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration, now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State v. Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue, and I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on in 4, whatever it was.
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi, and a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well, why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness.
Yes, sir.
Or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right. All right, let's talk about the TNT stuff.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period, so the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're talking...
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
Right. I have nothing further. Thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
That's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
So the 7 days that he's back home?
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records. But then the second warrant,
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that, and you...
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and that provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do, and that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury.
Thank you.
At the time of trial.
That will satisfy me. Thank you.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available, and I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that, and I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you. All right. The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts, and so I wanted to provide that to the
So
court.
I did see that and read it.
Okay, good, thank you. Let me get to my same page. I want to start, though, today with my presentation and my request with a little bit of history with this case, and as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required, and the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides, and I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better, and I think it creates just a more fulsome picture of things that way, and that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16, and so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence, and I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Morin case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, This is what we have. This is how we're going to prove this case. And for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, Agent Balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
Allowed to give an opinion about those last 7 minutes?
I'm sorry?
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion. Their expert to have an opinion.
You can't, and we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done, and to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage, and then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you, though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as the disclosure.
Did he testify for the grand jury?
No, nope. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony. But I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
That's just impeachment.
Well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that, and I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes. You missed that. And what could that mean? Couldn't it mean, as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more, too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands, and he's not allowed to talk about it.
You have to be careful about what doors you open, but
I agree, and when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. They have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline, and they didn't go home from the January 23rd and 24th hearing when the court said, your job's not done, I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickled things in, bits at a time. And that is just not the way the system works, and that's in violation of Mr. Kohberger's rights. And we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position, and that's the way to bring it back and keep the burden at the table it should be and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with Agent Balance.
Search warrant application include the analysis of the cell teller information?
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit, or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point is
dictated
that
it.
Were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance, but there are a few things. Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it. And let me tell you what I mean.
Talk about the adversarial part. I also looked then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the first time I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis, and then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
As I recall, the 47 said it was traveling southwest.
Well, that's what we say. That's what the record shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time, southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but it's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later indicates that it was traveling southwest of Pullman.
None of the search warrant affidavits have anything about 254. It was.
I understand that. My point is, the time was wrong, but the direction of travel is the same.
There are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, there is a, in the search warrant affidavit, I think as part of the PowerPoints, I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So I see what the court's doing. The court's saying, okay, you have this PowerPoint. What else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
I understand that's what you're saying, that's what they haven't done.
That's not what they've done, Your Honor. And
That's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue to you.
Well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So I'd ask the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them, and we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the...
That's not an opinion, first of all. It is an explanation of why they didn't submit evidence to CODIS. I'm not seeing how that's an opinion. That's just a statement of what the facts are.
Your Honor,
It's not expert testimony. That's, here's our policy, here's when we submit stuff to CODIS, and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
So the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is I don't really view that as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over-disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the stair-rail DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can...
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, it was the DNA of Y person, right? Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through everyone. I do want to talk about Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology, and we are...
Didn't you produce an expert who said that that it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. that
That
doesn't.
Dawson testimony about the degree of intoxication goes to
Homicide.
But first, we got to get to our big story at 4. We are learning new details about the deaths of a husband and wife in the village of Waukesha. Their teenage son, accused of killing them, was bound over for trial today.
Waukesha County reporter Brett Lemoyne is live with what a classmate told detectives about this case. Brett?
Yeah, well, prosecutors say 17-year-old Nikita Kassup didn't even have a driver's license when he took his father's vehicle and left the state back in February. Inside the family's home, investigators say Kassup's mother, Tatiana, and his stepfather, Donald Mayer, were shot dead. The medical examiner says both died on February 11th. That's the last day the couple was seen in person. It's also the last day Kassup attended classes at Waukesha West High School. More than 2 weeks after the shootings, police say Kassup left Waukesha County and drove around the country with the family dog. When he was ultimately arrested on February 28th in Kansas, police say they found a gun, $14,000 in cash, 70 pieces of jewelry, and his parents' bank cards. Back in their home, police say Kassup covered the victims' decomposing bodies with blankets. A classmate gave police details about a conversation she had with Kassup before he disappeared from school.
Witness A indicated that the defendant at times had talked about killing himself or harming himself, and had mentioned that first he would kill his parents by possibly shooting them because